This week that ended, His Excellency, the former Deputy President, Rigathi Gachagua, popularly known as Rigi, was in court over the issue of his impeachment. Originally, Rigi was fighting to get back his position on the ground that procedures were not followed to impeach him properly. He has abandoned that line, and now he's saying he wants to be compensated and be paid a lot of money. His entitlement as provided for by the retirement or vacation of office of the Deputy President. That's not the issue. The bigger issue is, after the impeachment, Rigiji has formed a political party called the DCP. And everybody is asking, after impeachment, what does that mean? If Rigiji has abandoned challenging for reinstatement to the office, does it mean that he has also abandoned the question about whether he was removed from office illegally? Rigiji has not abandoned that question. The only prayer he has abandoned is for reinstatement. Suppose the High Court finds Rigiji to have been removed out of office illegally. Can Rigiji be eligible to contest in 2027 as a presidential candidate? That is where the question is. Many will say Rigiji was impeached and he cannot contest in 2027 elections. Many will say, his followers will say, no. Rigiji is a candidate for 2027 elections. From Court Helicopter, we affirm that Rigiji, by law, he has all the qualifications necessary to be a candidate to face his former boss, Dr. William Ruto, in the ballot. This one, we have done a lot of research, and this is why Court Helicopter Dan Sanomari brings you the controversial version that Rigiji hate him, don't like him. The law is on his side. On the 10th of August 2027, Rigiji will be in the ballot of the presidential election. We went through, and this question is not the first time this question has been brought up. We went and checked in Constitutional and Human Rights Division, petition number 552 of 2012, as consolidated with the petition number 554 of 2012, petition number 573 of 2012, and petition number 579 of 2012. This was in the matter of the suitability of Honorable Uhuru Kenyatta and the Honorable William Samoei Ruto. What were the facts of this matter? The facts of this matter is that TNA recommended then Uhuru Kenyatta, Honorable Uhuru Kenyatta, and William Ruto to be the presidential and deputy presidential candidates for the 2013 elections. President Mwai Kibaki had served his 10 years term. An election was coming in 2013. So the question that was there is, can TNA recommend two people to contest, yet then Uhuru Kenyatta and William Ruto had been charged with the offenses of genocide at the ICC at Hague. They were charged with the offense of mass rape, mass killings, ethnic profiling, serious international crimes. It is serious than murder. International crimes are the highest criminal offenses in the whole world. William Ruto as a running mate of Uhuru Kenyatta, and Uhuru Kenyatta were facing these charges. So people went to court that these people cannot be allowed to contest in that election. These are serious offenses bigger than the offenses of impeachment in this country. Let us see what the judges found out. The petitioner's argument was that the first petition, he says, the first petitioner contends that after the international an examination of the evidence presented by the prosecution as well as the exculpability evidence put forward by the respective defense teams, the judges of the pre-trial chamber, the ICC, by a majority, confirmed charges against 4 of the 6 suspects, namely William Ruto, Uhuru Kenyatta, Joshua Arap Sang, and Francis Mudhaura. In committing them to full trial, the ICC observed that it was satisfied as to the existence of substantial grounds to believe that they were either contributors or indirect co-perpetrators to inter alia crimes against humanity committed in Kenya between December 2007 and January 2008. These were the post-election violence. Over 1,000 Kenyans were killed. Kenyans butchered each other. The contest was between ODM's Raila Odinga against PNU's Mwai Kibaki. Mwai Kibaki won the election. Raila Odinga did not believe that Mwai Kibaki won election. Violence erupted. The whole of the country was up in flames. So Justice Waki then listened to a tribunal and forwarded an envelope of 6 people to be charged at the ICC. 4 were charged. 2 names were discharged. They were discharged. So the question was, can these 2 people be in the ballot? The petitioner argued that Uhuru Kenyatta and Nani cannot be in the ballot. What did the judges find out? The judges in this matter, the 6 judges looked at the case, and the first thing they asked is what were the issues to determine. 1, whether the High Court has jurisdiction to hear and determine the petitions, and in particular, what is the role of the High Court in interpreting Chapter 6 of the Constitution? So the questions before the judges were, do we have jurisdiction to hear this matter as a High Court? 2, impeachment and ICC cases fall under Chapter 6. Does the High Court have jurisdiction to interrogate questions of impeachment and questions of violation of Chapter 6 within the mandate of the High Court? They quoted in paragraph 76, 78. They relied on the case of John Haron Mwau and 3 others, and the Attorney General and 2 others, 2012. The High Court held that this court, that is the High Court, should interpret the Constitution in a manner that remains relevant to its spirit. The court stated that, this is the High Court, we are conscious that our findings may be unpopular with a section of Kenyans who have preconceived notions about the elections, but we hasten to remind Kenyans that our undertaking is not to write or rewrite the Constitution to suit popular opinion. Let me repeat it. We are conscious that our findings may be unpopular with sections of Kenyans who have preconceived notions about the elections, but we are hastening to remind Kenyans that our undertaking is not to write or rewrite the constitution to suit this popular opinion. What is this in relation? If the question that time, people of Raila Odinga's wing believed that the High Court has power to stop Uhuru Kenyatta and William Ruto from contesting. So if the High Court was going to say it has no power, that section of Raila Odinga group will be very, very mad with the High Court. If they said Uhuru Kenyatta cannot contest, the section of TNA, that is the section of Jubilee, Uhuru Kenyatta and Ruto wing, will be very unpopular to the High Court. This is the question that we are going to see when the question of Rigathi will be put before the High Court. If the courts will say Rigathi will be in the ballot, the UDA wing of William Ruto will be so mad with the courts. If they say Rigathi will not be in the ballot, the DCP wing and opposition stronghold will be very mad with the court. But what has the court said? They will defend the justice of the Constitution. Remember, the courts are saying we do not decide cases because of the noise outside there. We decide cases based on the Constitution of Kenya. However unpopular that decision is be. What happened? What is the Supreme Court exclusive? A, the Supreme Court shall have exclusive original jurisdiction to hear and determine disputes relating to the elections of the office of the president arising from under Article 41. The judges said in paragraph 86, it is clear to us in unanimity, all these 5 judges agreed that there are potential disputes from presidential elections other than those expressly mentioned in Article 140 of the Constitution. A presidential election, much like other elected assembly elections, is not launched in a single event. It is, in effect, a process set in plurality of stages. Article 137 of the Constitution provides for qualifications and disqualifications for elections as a president. And this touches on the tasks of agencies such as political parties, which deal with early stages of nomination. It touches also election management by the IEBC. Therefore, outside the framework of the events of the day of presidential election, there may well be contested questions falling within the terms of the statute of elections or of political parties. Yet still, the dispute could still have clear bearing on the conduct of presidential election. The judges proceeded to say in paragraph 89, the heartbreaking news from the judges of the 5 judges of the High Court was, it is therefore clear from the foregoing that any question relating to the qualification or disqualification of a person who has been duly nominated to contest the position of President of the Republic of Kenya can only, oh my God, be determined by the Supreme Court. This includes the determination of the question whether such a person meets the test of integrity under Chapter 6 of the Constitution in relation to presidential elections. These 2 questions cannot be determined or considered by this court, the High Court, outside the context of elections that are due to be held on 4th March 2013. So the High Court rejected the invitation to determine whether Uhuru Kenyatta and William Ruto shall be in the ballot, because it said that is a question for the Supreme Court. One thing that comes out very clear, the question whether Rigathi will be in the ballot will not be determined by the High Court. It will not be determined by the Court of Appeal. It will be determined by the Supreme Court. Who are the members who are going to determine this question? This is the latest born son to the Supreme Court, Justice Wasame, is going to sit and determine the fate of Rigathi, whether Rigathi is going to be in the ballot. You now understand why the Supreme Court is life and death. Men and women of the Supreme Court will determine the fate of Rigathi. It is them who are going to decide whether the DCP leader can be in the ballot. Wakili Dan Stanomari always bringing it the way it is, but one thing is certain, Wakili Dan Stanomari will not be in the ballot. But I'll not be in the ballot because the law prohibits me, but I will be loyal to Court Helicopter to bring to you controversial positions of the law. Keep watching and enjoy your weekend.